Last Friday, na Parliament na showdown between Minority Leader Baffoe Bonnie and the Majority Leader Mahama Yaraga on the floor of Parliament. Na nyasem kitu akra abusafo ene obe enjoy this episode right here on Anajantua TV. Na ebane say unim say Monday and ye be vetting acting Chief Justice Baffoe Bonnie. Justice Baffoe Bonnie. Na minority no more issues kakra last Friday. No person komo hot is our vetting process no. Omunyina so ye den Majority Leader Mahama Yaraga so ne dey be hwim ansa na speaker rule. Na speaker rule no abusafo, it was very interesting. Hey, Baffoe Bonnie versus Mahama Yaraga, and of course Speaker of Parliament Alban Bagbin jina fifth no to ayiram. Me say you enjoy this showdown. You be gum at the amount higher than Anajantua TV. Pacho, over click subscribe button. I'm Mrs. We have bell notification icon and that's no. Now what click it. Send a video to drop here. You'll be the first person to get it. But don't forget to turn on the notification bell as well. Video no share. You believe you comment in the comment section after so. What channel for France and you be ashamed. The last Friday now was a comedy bro, but you see about a guy no CC and who you. The only say na me task me information in na fe me be keka ni sim e de amount. The only say last Friday and a minority no echo pushy for proposal be say omo person mo hot vetting process for acting Chief Justice Justice Baffoe Bonnie on Monday, which is edachna. Omo nyina so ne say obekaya get to tokonu the former Chief Justice and the previous Chief Justice no ye the two asekonya man the two ahwefom say bugbram and then the replacement aba na asem na kopie mu court a ye tu ho daware eno ana Baffoe Bonnie and then the minority ni say issue of court there and kamunya botre ni yen clear issues na court ni nyina ewie and sakrampo na kia push say ye ba be vetting the replacement because obe vetting the replacement asem no court no kwa ni nwie ti dey na obe vetting the replacement eho and a kofa showdown on the floor of Parliament in the by na Baffoe Bonnie about 4 minutes and 5 minutes video. No nsema no nyina so na on person majority dey pushy for the vetting of the acting Chief Justice Baffoe Bonnie no enie and so Baffoe Bonnie to on the floor of Parliament enie menye nsema nka me wakwa kotie at the point na say emotions ni wasoro ebinim kwampo na he was shouting minim de kwa video no we are comment now they are jamming e comment section ma be kan e de amount
committee confirms certain provisions, it becomes part of the report. That is it. Yes. So, Mr. Speaker, don't take me to that part. Mr. Speaker, with respect, he has confirmed that there has been a program. So, Mr. Speaker, let's not belabor. It's a fact. We are saying that he should take that off. He should withdraw that bit so that the original component of the business committee's report remains without any vetting whatsoever on Monday. Mr. Speaker, in any event, we, the minority, as law-abiding as we are, filed a motion several days ago, and I've done several follow-ups. Mr. Speaker, our minority should not be taken for granted. It should never be taken for granted. We are encouraged at all times that we should be law-abiding, follow procedure, and we'll be vigilant in that process. So, Mr. Speaker, awaiting all of this, the majority leader cannot just announce to us that Justice Alaba Esabato Konu's prayer does not matter. She is a Ghanaian who was appointed. She has submitted herself to all due process. Her rights must be respected. This Parliament must, with the greatest respect, rely on its own precedent not long ago and allow the court to determine the matter. It should be our collective call on the acting Chief Justice to quickly empanel the court. It must be our collective voice to encourage the Attorney General to file a defense. It must be our collective voice to encourage the Attorney General to go to the ECOWAS court and file a defense, rather than we being threatened by the chief whip of the majority that vetting will happen with all his might. We are not dealing with might. That vetting will not happen. It will not happen. You must follow due process. Follow the law. Do the right thing. We, the minority, will not shut our mouth. You can follow due process. Mr. Speaker, I want to resume my seat by saying that my submission does not in any way seek a ruling from you. I am not seeking a ruling. I am rather seeking the indulgence of the majority leader, who knows the rules, to do the needful by withdrawing this aspect of the report that is going to be vetted. Mr. Speaker, we know how to move our case and we'll do the needful. But this one is not a motion bringing it up for you to make a ruling. No. Mr. Speaker, that said, I will rest my case and hear the majority leader.
Enti owie na Mahama Yaraga majority leader. Afenya maki anusi ya na majority leader Mahama Yaraga so bae. Ono no so na dwenkyere bae. Na at the point oka na afenyo aka oka na we aka, it was a proper showdown on the floor of parliament. Mahama Yaraga so be kyerɛ wa the konti a was a process to go through, and they had done all the right things as required by law. Enti omo ho kwan ese ye be vete Justice Paul Baffoe Bonnie on Monday. Na enyasem kitakra again kono Mahama Yaraga ononso nsema odi to the floor of parliament on this chief justice vetting issue. There was a showdown. What the Afanya Markins can now is the turn of the majority leader Mahama Yaraga.
I think it is important first and foremost that we are reminded at all times that we are not just speaking to ourselves, we're also speaking to a wider audience. And so I always make it a point, as much as I can, to speak directly to the wider audience by trying to break down things to a very basic level. When you break down things to a very basic level, sometimes people who think they know realize that they actually don't know, and then they will appreciate. Now, the Chief of Staff had issued some directives regarding some recruitments that happened after the NDC came into office. And somebody went to the Supreme Court to try and get the court to intervene and determine that that action of the Chief of Staff was unconstitutional, it was wrong, it was a violation of the rights of those individuals. Then the minority leader brought a motion to this House, urging this House to take some decisions regarding the action of the Chief of Staff. So I raised an objection on the grounds that because someone has already gone to court to vindicate the rights of the people who were dismissed, it will amount to interference in the work of the courts for this parliament to also go into that matter. This parliament was asked to act in a matter that was quasi-judicial. Once a judicial process was already underway. And so I said, you will be interfering in the work of the courts if they have started a judicial process of determining the rights or otherwise of those dismissed. Then you also come to this parliament and say we should also start another process of determining the rights or otherwise of the same people. That will interfere in the work of the judiciary, because their main responsibility constitutionally is to vindicate rights. We primarily are to enact legislation, hold the executive accountable, and sometimes hold the judiciary also accountable. So our position is secondary to that of the judiciary in this matter. That was the context, and that is how the Speaker concluded that I was right in that instance, and therefore your motion should not be admitted. Now let's come to this present instance about the appointments committee. In this instance, you are saying that a referral that has been made by the Speaker to a committee of this House to exercise a function that constitutionally is within the province of that Parliament, a nomination which the Speaker has accepted and which he has referred to a committee for the committee to process. And I once again bring your attention to the fact that the same Supreme Court has said that in matters that are primarily the responsibility of Parliament, once Parliament starts dealing with those matters, no one anywhere can stop Parliament from dealing with those matters until Parliament has completed the process of dealing with that matter.
You understand?
The Supreme Court has said that severally. And he just cited two cases in which members of this House have gone to the Supreme Court to try and get the Supreme Court to order this House to stop considering matters that the House was considering on the grounds that they felt it was unconstitutional for Parliament minority leader. Reference to the Constitution, to Eskin May, to all those things don't really make a difference. The matter is so simple and so basic. The Supreme Court of Ghana has said that when this Parliament is engaged in its primary responsibility, it will always allow this Parliament to go through that process to the end. And then if the outcome is wrong or goes against a specific provision of the Constitution, then they at that point can make that determination. But once they are seized with jurisdiction and they are dealing with the matter, they will not interfere. I haven't seen a ruling changing this position of the Supreme Court. So as for ECOWAS, yes, even ECOWAS court will always tell you that you should have fully exhausted local remedies before you come to the ECOWAS court. So if you are already in the courts of Ghana trying to vindicate your rights, you haven't finished in Ghana, then you jump to Abuja. When you have not yet exhausted local remedies. I'll be surprised if ECOWAS court delves into your matter. I'm saying this because I have been a member of ECOWAS Parliament for close to a decade, and I know how that court functions. So I can assure you, without making any pronouncements now, that the principle at the ECOWAS court is that you must have exhausted local remedies before you go to ECOWAS court. Mr. Speaker, Mr. Speaker, I plead with my colleagues. I know that the circumstances surrounding the removal of the former Chief Justice is a matter that especially my brother, the minority leader, has fought. He has embarked on street marches. In the process, some policemen even alleged that he became physical against them. I can understand. I can understand that this is a matter that he is personally very passionate about.
Majority Leader, conclude.
But the Constitution is very clear on these matters. The nomination of the Chief Justice is properly before this House. It has been referred to the committee, and the committee will sit on Monday. I urge him to appear before the committee as a member. You can ask all your questions. The Chief Justice nominee is ready and available and willing to answer all questions put to him, and very, very capable. If at the end of the day, there is any decision by any court in this country, I'm sure the courts will find a way of crafting a mechanism for enforcing their decision. The courts will find a mechanism for crafting the enforcement of their decision. Mr. Speaker, the courts, after we have completed our work in this House, have been able to strike down the conclusion of the work of this House. In that ruling led by Justice Yoni Kulondi, they annulled what we did in this House. So please, allow the system to work. Allow the system to work. So, honorable colleagues, I have presented to you the business statement for next week. The minority leader is a member of the business committee. The minority chief whip is also a member of the business committee. And so this business that we have presented to you is business that we agreed together as the business of the House for next week. And we urge you to approve it so that we can move on. As for the referral to the committee, that was done some time ago. It was not really part of the records of the business statement of this sitting. It wasn't. It is an old referral. What we did is to attach records of the old referrals to remind members that those referrals are still pending before them. But it is not a matter for decision today. The work of these committees are not matters for decision today. It is just to remind members that these assignments are pending before them. So the question of the appointments committee and what they are to do on Monday is not for decision today. It is a matter already referred by the Speaker to them. So if you are going to challenge the decision of the Speaker on that matter, you know the procedure to use. You know the procedure for challenging a decision that has been taken. So the Speaker has already taken a decision referring the nomination to the appointments committee. All we are doing is to remind all committees that businesses are pending before them, that they should endeavor to accomplish those businesses and bring their reports to us for decision. So you cannot get up and, like somebody did in secondary school exams, where the question was, what is a tree? Then he says, oh, a tree has branches. Sometimes birds perch on the trees, and one may ask, what is a bird? And then went on a tangent of explaining and describing a bird, because that is what he had prepared for in the exams. I am saying this because I know as a fact that he had filed a motion seeking to challenge the authority of this house to have the nominee considered by the appointments committee. He filed the motion. He raised it at conclave, and I reminded him that you cannot stop this parliament from conducting its lawful business. I reminded him, and he told me, listen carefully, please listen carefully. He told me that he had prepared to argue that motion, and that even if I wanted, he would give me copies of his arguments that he would prefer. That is why I'm saying that he had prepared on an examination about a bird. He had prepared to argue a motion. He had prepared to please listen. He had prepared to argue a motion. He had prepared to argue a motion on the constitutionality of this house, considering the nomination of the Chief Justice. So even though that motion is not properly before this house, and what is before this house is the business statement for the next ensuing week, he decided to argue his motion.
Honorable Majority Leader, conclude. Kindly conclude.
So, Mr. Speaker, I think that the issues that he has raised are not properly before us. There's no issue about the sitting of the appointments committee. That is a matter decided already by this house. What is before you is the business statement, so that we can schedule activities for next week. Mr. Speaker, I thank you.
For parliamentarians and a tontoni nyina wie no ana fe match referee no the central referee no ebaye which is the Speaker of Parliament udim say omotwe tontoni nyana ye benada hiafo na tie akwanyam bigide se na speaker na opie kakra I mean oba betrase ana obewurule ye na obeto ayeram ana obegina fifi say ye nyina jitim say I mean Speaker of Parliament when the be referee did obeka no ana de ye adwuma ni rule ni say ontimi admitting minority in the proposal because in the first place Parliament here an arm of government. They are supposed to be independent. I mean, within another arm of government, it shouldn't affect parliamentary process. Until Nimkas almost set our precedents, no. Until ultimately admitting minority the proposal, in fact, or dismiss it. Speaker of Parliament, Alban Bagbin, or using Chimo de Baya de Contia, or dismiss minority the proposal on the vetting of Chief Justice Baffoe Bonnie.
To either direct that the motion be printed or the motion is to be returned as inadmissible. Honorable members, I have considered deeply the proposed motion. I considered the text and I concluded that there was no basis for me to exercise the discretion to admit the motion. I have a copy of the proposed motion here. The motion, in summary, suggests that Parliament, as an arm of state, should stay its hand until another cognate arm of state takes action on a matter pending before it, even when there is no definite time for that arm of state to take the action. I find this suggestion constitutionally and procedurally unsustainable. Article 144, Clause 1 of the 1992 Constitution gives Parliament a clear and continuing duty to consider a president nomination for Chief Justice. That duty is not conditional on events elsewhere. There is no constitutional or standing order basis for Parliament to hold the process simply because there are pending cases in court. Should I accept that argument, it will mean that any litigant could hold Parliament hostage, that is, file a case and freeze the work of Parliament and its committees. That would undermine the concept of separation of powers and paralyze the constitutional machinery for filling, for example, in this particular case, key offices of state. Honorable members, I'm very mindful of Article 2 of the 1992 Constitution, especially Clause 2 of Article 2, which vests the Supreme Court powers to make orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declarations it has made. This article clearly states that should there be any unconstitutionality regarding the removal of her ladyship, Justice Tokunu, the court is vested with the power to so declare and make all necessary orders needed to restore the status quo. To that end, I'm of the view that courts can continue to hear whatever matters are pending before them, but until there is an injunctive order, Parliament's authority remains intact. Judicial independence should not mean legislative paralysis. In any case, I have consistently questioned whether the Supreme Court could use its injunctive reliefs to stultify the work of another arm of state. Is that the purpose of that relief? Honorable members, procedurally, I'm also mindful of Order 103, Rule F, which suggests that a motion shall not be a subject matter of an action in which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of the parties in the action. I have considered the provisions on admissibility of motion, and I submit that the proposed motion is out of order. As I have already indicated, I am convinced that the Supreme Court is vested with adequate powers to reverse any action should they deem them unconstitutional. This matter I have discussed with the minority leader who was bent on the motion being admitted. It's not that I'm just saying them now. But he gave me notice that he will definitely air his views on the floor. And I think that is why, as the majority leader said, even though you were discussing football, he brought in Ampe. In summary, honorable members, the major points of this ruling is that the motion is inadmissible.
And you hear the voice of Speaker of Parliament Alban Bagbin. Meaning what you make of this video, you can leave your comments in the comment section of so or like you know what for Frost and you be ashamed. To the Omni say Monday, Ebetoja, acting Chief Justice of the Republic of Ghana, Justice Paul Baffoe Bonnie. You better vetino. You better has it another to TV near the Munina Abraham. Bacho on subscribe channel. You intend to subscribe. My we bell notification icon over turning on video the drop here on Sabek. And another Kojojantua, the Sokato man, Dr. Samuel Kojojantua, the Sokato man, the fireman, the lion guard, Enche. In our next episode right here on Nana Jantua TV. Makramo.